Let me see. We have Dr. Asante. I don't think we have Dr. Asante, but we have our moderator for tonight. That's Kweku. Hi, Kweku. Okay, so I'll introduce them. So Oliver Barker-Vormawor is a Ghanaian lawyer and a civic activist. He is a senior partner and co-founder of Merton and Everett LLP, a law firm based in Accra, where he engages in legal practice alongside public interest advocacy. He is also executive director for Democracy Hub and was the convener of the Fix the Country movement, which was very popular last year. So he has consistently engaged questions around constitutional reform, public accountability, and the relationship between state power and citizenship. And then tonight, he joins us to share his perspectives on constitutional reform and the role Ghana School of Law students can play in public engagement and democratic accountability. Thank you so much for being here tonight, Oliver.
I'm happy to be here.
Okay, so let's go to Noah. Hi, Noah. So, Noah is a Ghanaian lawyer and the founder and managing attorney at Princeps Legal, where he works across areas including dispute resolution, human rights, and public interest litigation. In 2022, he served as a fellow of White and Case LLP's Global Citizenship Program, working in the firm's New York office. There, he supervised global pro bono projects in various service areas. Importantly for today's conversation, Noah was a research lead for the 2025 Constitutional Review Committee. And in that role, he worked directly with topics surrounding Ghana's constitutional framework and contributed to proposals aimed at strengthening democratic governance. So tonight, he's here to help us ground our discussion in the realities of the constitutional review process and what it means for us as Ghana School of Law students. Thank you for being here with us, Noah.
Thank you for having me.
Okay, I still don't have Dr. Asante. Oh, he's here. Okay. Hi, Dr. Asante. Good evening.
Good evening. Good evening to everyone. I hope you can hear me.
Yes, we can. So I would introduce you, then we can get straight into it. So Dr. Kojo Pumpuni Asante is a lawyer and the Director of Advocacy and Public Engagement at the Ghana Center for Democratic Development, where he works on governance, accountability, and anti-corruption issues. Over the years, he's been deeply involved in policy discussions around constitutionalism, democratic accountability, and institutional reform. His perspective is particularly useful for understanding what constitutional reform means for us beyond the text and also the possible implementation challenges. So tonight, he joins us to help unpack the substance of the constitutional review process and what it realistically means for governance and public accountability. So thank you all for being here. We are grateful to have Mr. Keiko Asante, who's a career journalist with Joy News and also a college student from our UPSA campus, to facilitate this conversation. So over to you now, Kweku, and I hope we all enjoyed this conversation.
Well, thank you very much, Otinewa. The lineup is stacked. It's very, very powerful. I mean, there's no better team to discuss matters of this nature than Dr. Asante, Oliver Barker-Vormawor, and our brother Ephraim Noah. So we'll get straight into it, and colleagues will get to a point where we will do some questions and answers. If you have also contributions, you can always come in and then you can share that. So I want to start with you, Oliver, because you've been saying a lot about constitution review long before it became a bit fashionable to be talking about it like the way we are doing. And in fact, what you were calling for was not just a review. You wanted a complete abolishment of the old order, and you wanted a new constitution to be written. There's so many people who disagreed with you, and they did so strenuously, and others held a different view. Why did you hold that view? And does the current way we have done things with review satisfy you?
I appreciate it, and thanks for joining the conversation. I mean, I think our advocacy has been consistent on the point that the way in which we unravel some of the governance problems that we have do require us to be able to relook at the constitutional document and rethink it. Now, the reason why we've been talking about a new constitution for a new generation is primarily for two reasons. One, there's of course content questions about how can we substantively reposition the constitutional document in a way that better anticipates, the questions of today and also better prepares for tomorrow. But also there's the process question, right? Which is, how many constitutional amendments can you do in order to ensure that the document is fully reflective of the needs of what we are trying to push the document into. Now, our biggest concern is that because the structure is very limited, the structure, and by the structure I mean the mechanisms by which you review and amend the Constitution can be limiting, the effect is that it limits imagination. And so we become purposefully conservative in terms to reimagine society. It becomes, what kind of amendments do we think can pass, rather than what kind of amendments do we actually need to move the constitutional framework forward. And so that's why the process of a new constitution has always been part of a big advocacy. Now, so a lot of times people say, but well, it's like throwing or even you use to do away completely with the old order and throwing the baby with the bathwater in the conversation about the new constitution. But we're saying that it doesn't necessarily mean that if the old constitution guaranteed the right to fair trial, and so that the new project will then say, no, we are taking a binary, everything that existed in the old should obviously not exist again. That's not the point. The point is that when it comes down to it, if you take the constitution, the first constitution review process, and the range of recommendations that were done in that 1,000-page report, one of the reasons why we believe it failed is that because of the technical process of reducing all those changes through a review mechanism. And those questions, I believe, have not even left the current process about how many of them can go through and how do you sequence them to be able to make that work. And that's why the advocacy about the new constitution was part of the conversation. Because if we take what happened in 92, we went wholesome to adopt a whole new document, right? And in that process, we were then able to, right our wrongs or do a new project altogether. And I think without one of the things of doing it now, which allows us, is that we do so away from the barrels of the PNDC and the military era that was breathing down our neck. We write a new constitution within a democracy, and I believe that can produce a substantively different document than what we currently have.
Yeah, interesting. So, Noah, given that you had such an involvement in the writing of this constitution right from get-go, I mean, the review that we have done, I'm sure in 92, 91, 92, when they were doing this, I'm sure you were a very young man or had not been born. So I correct myself with that. But you look at what Oliver said about the way the process is limiting. I mean, look at the number of recommendations for amendments that your committee has brought, the committee you served or you worked with has brought, as against the writing a new constitution, which gives you like a clean slate. Start afresh. What do you make of that vis-a-vis the work you did?
Yeah, so I totally agree with Oliver. I think from the onset, I have also held the belief that Ghana needs a new constitution, right, for a number of reasons. But I think what we have now is the willingness of the current government to see to the amendment of certain provisions in the constitution than having a whole-scale adoption of a new constitution. And like Oliver said, the conversations clearly indicate that amending the constitution to translate the various recommendations made by the committee into the 1992 constitution is going to be challenging, right? How are you going to go by that, especially those recommendations that will require a referendum? So I agree, it is going to be quite challenging. And I think the skepticism around the conversation even suggests that if between now and the next 4 years, we are able to get about 50% of the recommendations through, that might even be a miracle. So it would have been easier if we were adopting a new constitution, right? We are very certain that constitution that are still relevant could simply have been reproduced in the new document, and those proposals that the 2011 Constitution Review Commission did, and what this current committee has also provided, could have been put together, and then we could have produced a new constitution that reflects the current demands of society and even how society has evolved. But I think we have to make do with what we have. And I'm hopeful that though there are certain challenges, the implementation committee that is likely to be set up will think around this and find some viable avenue to address those challenges.
Yeah, I mean, Dr. Asante, if my assessment of you is right, I think you're a bit conservative in this kind of conversations. I'm not sure you really want like that wholesale thing. And so it'll be interesting to get to know what you think of that. But also, briefly, if you can touch on this for me in your submission, there's almost that kind of euphoria around these processes around these times. But mostly we are unable to do anything with it. We have the Professor Fiajo Committee's report that had just been put on the shelves since President Mills. And then President Akufo-Addo came and then set up a Constitution Review Consultative Committee. In fact, it was done through the Ministry of Parliamentary Affairs. In fact, as of like June, July of 2024, when there was just about going to be an election, the committee was still working. At the time they presented their final report, it was only almost election, and there could be nothing to be done about that. And then went into an election, the new government came, immediately set up a committee chaired by the respected Professor Kwesi Prempeh. And they've done their work in quite record time. If you kind of see the report they've given to the president, almost 700 pages. But then it seems things have died down a bit, and we don't have so much time to get this into implementation before a new government comes, because we know this president will not contest the next election. At least for now, the Constitution says that's so black and white. The euphoria around this thing and how it's dying down, do you get a sense that we can pick up on this opportunity and make some real changes while we have it?
Yeah, good evening again. And first, let me disabuse anybody who thinks I'll be described as a conservative. I mean, actually, it's the first time somebody's called me
on these matters, I suppose.
Oh, not at all. But I mean, I think the points that Oliver and Noah makes are very, very important on the procedure matters. But just to address your question about euphoria, around these things, I think yes, we are lawyers here or aspiring lawyers, but really, if you break this down, it is really a real quest in search of answers to many, many problems, that governance problems, I think, but also development problems that we face as Ghanaians. If you were to, I ask you, Kweku, to list me your top 5 problems that you have with Ghana, I'm sure all the frustrations you have with very bad public services and the way that our politics, kind of disables our development and all of that, will be one of the things that you raise. And that is, when you reduce it, that is what it comes down to for me. It is a rare opportunity to try to fix some of our problems. The Constitution is definitely not the panacea for addressing all the challenges we have, but it is fundamental that at least we design a constitutional architecture that enables development, because that's what everybody is complaining about. It's like, we go and line up to elect people every 4 years. They promise us all kinds of things, and then we all, leave the place 4 years later with buyer's remorse, and very upset with ourselves, and it seems like there is no end in sight. So this is where this constitution process for me is all about. It's about us as citizens trying to address a problem that we all see, and it's just that the pathway that has been laid out to do that is difficult. But my view, and I'm always very optimistic about these things, is where there's a way, where there's a will, there is a way. So I start from the premise that we cannot continue the status quo. How do we then move forward? And we have an opportunity, so let's get it done. Euphoria, yes, there is excitement always at the time of inputting into the process, but we have never crossed this bridge. Because as you say, this is the 3rd time we are doing it. We need to get beyond this to the point where we are actually amending provisions of the Constitution. And I think that is where we all need to work together to get over the bump,
It's interesting. And the president, when he received the initial draft of the the committee, the main outlines of the recommendation did indicate that in January or right after Christmas, that was his words, there will be an implementation committee to get into this. That hasn't happened yet. In fact, subsequent to that, we've had the education minister talk about whether or not there will be a white paper setting out what the government accepts or not, and whether or not the government is just going straight to an implementation committee. We haven't had that. Today is 1st of February, and we are going to go ahead, especially because they are part of the process that is a bit tedious, especially if you have to amend entrenched provisions, even some of the unentrenched provisions, the process they have to go through in Parliament, quite tedious, and not just tedious, the kind of time it takes. And so the expectation will be that we'll get into that. And when I get to Noah again, I'm sure I want to take his view, what the committee is thinking. But Oliver, what are some of the things that stand out for you in the recommendations that have come out so far? They're big ticket item, 5 years for the president. Someone said that, listen, that is really, well, how do you arrive at 5 years? Why not 6? Why not 7? Why not stay at 4? Are you saying because Nigeria is doing this, Nigeria is doing that? So there's a lot of interest around some of the things that the committee has brought out. I wonder which of the recommendations stick out for you and what you make of them.
So I think for me, one of the and I've talked about this several times, that is that I'm more interested in the design theory that they propose. And I think the biggest thing for this committee is how they have unblocked a critical roadmap to how we amend the Constitution. So they have proposed amendments to Chapter 25 of the Constitution, which focuses on how we amend the Constitution. And critically, what they are saying is that because we have stuck the Constitution into two main frameworks, entrenched provisions and non-entrenched provisions, that there's a vast majority of the recommendations that they're going to be making that would each require referendum. It makes it almost impractical or impossible, because you can't lump all the questions into one referendum, one document, which means that there has to be a series of referenda on each particular topic. And what they're proposing is that, why don't we have one referendum which focuses on reorganizing the amendment chapter of the Constitution, so that critically you have a new tier of articles that go into what they call the semi-entrenched part of the or semi-entrenched provisions. And the essence is that, so you take a lot of the issues, whether or not there should be the chief of defense staff, or things that attach the armed forces, things that touch parts of the decentralization framework, things that touch so many aspects of the Constitution, or even whether or not you can change anything relating to Article 88 regarding the Attorney General's powers, right? All of those would have required referendum. And they're saying that let's bring that into a second tier, which is the semi-entrenched provisions, which would then also go through Parliament, but to require 75% majority to be able to pass. I think for me, that's something that we have never, or it helps kind of make easy the process of amending our Constitution. I think it's something that whatever comes out of this provides us a good roadmap and framework for dealing with 1992 related issues. Then also, of course, I'm quite interested in about some of the ways in which they propose to advance sort of the chapter 5 on human rights. So one of the biggest things for anybody who has done human rights litigation in Ghana is that you go before our courts and you're trying to vindicate a right, and then we get blocked and stuck on whether or not the right is absolute and whether there should be clawbacks to it, which is like a very regressive question to ask. Nobody is asking whether or not the right is absolute, but how do you protect the right in that particular instance? And what is being proposed now is to reorganize the limitation clause of the Constitution, which requires a detailed, almost 5-step process by which you justify whether or not this restrictions is absolutely necessary in the particular circumstances. So perhaps gone are the days where you go and you're seeking the freedom of assembly, and the judge tells you that Christmas is for merrymaking, and some of the ridiculous things that we have seen happen. So I think that, for me, those are some of the key things that unblock some of the rights-based issues that can enhance advocacy in the Republic, I think.
So I wonder what you make of this term limits thing. Of course, the committee says that is cast in stone, but the point having to do with 5 years, how arbitrary is it? I mean, how do you get to 5 years? Why not 6? Why not 7? Why not 8? Why not 10? I mean, the numbers, what went through I've had an interview with Professor Kwesi Prempeh for Joy News where he explains that, talks about the sub-region Nigeria, US, and how a lot of countries are drifting apart from that. But we sort of have an idea of how our country is run. When you
Yeah.
get stuck up with a bad president, you have to do one more year that could
Yeah.
lead up to 10 and all of that. I wonder what you think of that.
Yeah, I mean, listen, all 10 proposals are how do you call it, arbitrary, right? Like there's no exact science as to why. So perhaps it's more tradition than anything to go with. But I think the biggest question for me, I've said, is that the proposal, for instance, in terms of the realignment of chapter 25, is that they want that question of the length of the term to be brought into the semi-entrenched. And I say, I think this is a question that the people should vote on, right? I think that it definitely needs to go to the people of Ghana, and they have to make that call whether or not they think a 5-year term should have. I am in my politics very apprehensive of the political class. So there'll be no surprise if I come out against it, because I genuinely think that the way in which the political class manages power, 1 year is even too long, in terms of how I view these things. So I think that the people should reserve the right to make that decision in ultimate.
So Noah, because you were in there, I will come and ask you a few things, but I want to go to Dr. Kojo Asante. Doc, do you think we have been radical in the kind of changes that we have proposed? I mean, there are those who still hold the view that we have been rather very cool and cozy about some of the themes. We have touched a few places, but even the changes haven't been changes that are seismic in the way that it shifts the current architecture of our democratic and constitutional governance. I wonder what you make of that.
I think the current 1992 constitution, is a good constitution. I mean, if you compare it to many constitutions around the world, it has very strong foundations, right? So what this is trying to really do is to really realign some of the incentives that are designed in the constitution to be able to get to the goal. And the goal is in the title, moving from an electoral democracy to a developmental democracy. And what it is really, it's a journey from democracy to development. And what we haven't done well is governance. Because for you to be able to translate your democracy to development, you need good governance. And if you want good governance, the state has to function and function well. So how do you free the state to be able to deliver quality services, from security to protection of rights, to health, water, housing, education, our day-to-day bread and butter stuff, which every citizen wants from the state? That is what we are missing. So what it really attempts to do is, first of all, free the president from all the burden of these appointments that basically entrench sort of, political motives and all of that. How do you reorganize political parties, or, discipline them in a way that they don't disable the state from functioning, right? So all the proposals that are put in there about establishing a regulator of parties to make sure that parties, their internal democracy is sacrosanct and mimics what you want from the state. Because remember, the political party, in many respects, is basically a rehearsal for who comes to manage the state, right? So if the political party's processes for electing its executives are corrupt, how do you expect to then have a clean government or a clean state? If the processes for choosing our leaders is monetized to the extent that people are borrowing money from even illicit sources to come into government and manage the state, how are you going to fight corruption? How are you going to fight crime? So these are basic issues for us. But at the moment, the incentives around the Constitution, or what incentives the Constitution is generating, is not enabling the state to have the independence and the freedom to be able to do the stuff that it needs to do for the city. So for me, I wouldn't say it's radical. What it does is that it tries to solve a problem. And that's what I like about the proposals. It ensures that all the key components that we need in order for us to create a system where we can enjoy our rights, our political, social, economic rights, but at the same time, be able to deliver basic, bread and butter stuff. And if we're able to accomplish that, we will be, I think Denmark now is the happiest, they are the happiest people, maybe until the Greenland matter, but maybe Ghanaians might be the happiest if we're able to do this.
Yeah. Noah, I want you to talk to some of the things Oliver raised, but also the imagination question. How imaginative were you when you sat at the feet of all these people, the members of the committee, while you did the kind of research you did for them and coming out with some of these recommendations, especially given some of the things people have been talking about? Let's talk about Article 71, for instance. And those who say that the recommendation that the committee makes does not really fix the situation. You just do another independent committee of a sort. When we have the people saying that the entire system is broken, you fix it by perhaps designing a certain scale for giving salaries to these so-called Article 70 to 71 officials. The imagination process, were you guys imaginative enough? And how do you respond to some of the issues that have been raised by both Dr. Kojo Asante and Oliver?
Yeah, I think Doc and Oliver basically touch on the philosophical basis on which the committee operated. Now, the committee believed that its task was to solve problems that have arisen since we deployed and implemented the Constitution for the past over 30 years, right? And there are some of the issues, as Doc mentioned, you cannot solve them within the Constitution. And I think the Article 71 issue was one of them, right? You need to understand that you need focused research on how to provide some emolument or some remuneration for persons who come into government or who occupy certain offices to provide services to the entire governance machinery. And the committee believed that with the time allocated to it and its duty to address some of the challenges that have arisen under the Constitution, it was not in that right position to conduct the research outside what it could do with the limited time and the resources available to provide the necessary language on how to do it. And so in the committee's mind, there should be a committee, some other committee that would focus on emolument issues. And I think one of the things that people who read that recommendation need to also have in mind is that the committee is not, the way the committee addresses Article 71 is that it treats all issues of emolument under the Constitution. So those which do not even come under Article 71, it gives all of that to the emolument committee. And that is very important because now we're going to see some equity in how emoluments benefits are distributed across the different positions held by people in the general public and civil service, and those who simply come into the 4-year term of government, right? And I think that is very important. When you listen to a number of people who have shown concern about Article 71, the touchstone of their sentiments is usually based on the lack of equity. Why should we be paying parliamentarians ex gratia? Why should we be paying certain persons who occupy certain offices these huge amounts of money when the ordinary teacher, when the ordinary civil servant, when the ordinary Ghanaian is not earning that much or is not considered in that light? So I think that's what the committee seeks to address. So it cuts across the traditional Article 71 office holders, goes into the civil and public service, and try to streamline the emolument benefits that accrue to all of these people based on the services that they provide to the nation. But I think even beyond that, as I said earlier, the committee's understanding was that it does not want to complicate issues. It wants to solve those issues that are apparent since we started applying this Constitution to our governance. And so for every recommendation that you pick, there is a problem that the committee recognizes, and through the committee's thinking and considering the local issues and then how previous committees have tried to resolve the issue and looking at some comparative decisions that have been made by other committees outside outside Ghana and even sometimes outside Africa have tried to resolve the issue. The committee, through the research that we did for the committee looks at that and then comes out with a more practical, a more realistic recommendation that will solve the issue as being the basis of a number of recommendations. So if you see any recommendation that we might think the committee was not too radical, we should understand that in some instances, the committee believes that some of these issues are best addressed by legislation and not the committee micromanaging the entire process of addressing that issue. So the constitution will provide the broad framework, and then Parliament will be called upon to pass specific legislation that will address that issue, or it will be given to some newly created body or some existing body that will have the mandate to do deeper research to address the issue.
Really interesting thoughts there. Oliver, did you want to say something?
No. I mean,
Okay.
I
Right.
wanted to.
Okay, Doc, please let's hear from you.
Yeah, I just wanted to give an example of this, what Noah was talking about. I mean, if you see the proposal to set up a devolution commission, for example, to handle questions that have come up like proportional representation, because there's a deep belief, at least from a lot of the consultation, that that is a much fairer system, a much inclusive system for local government or even national government, and has to be considered very seriously. But it is not easy to just design that in the constitution from the off. You do need reflection, and maybe even a much more technical engagement to come to that decision and how to roll it out. If you take the issue of election of MMDCs, yes, there's a recommendation that we should elect MMDC. It is something that has been on the table for, a decade and more. But then there's also the question of, how are you going to elect mayors in over 260 districts, some of them that are not even viable. In Accra alone, you will elect 33 mayors. So you have a mayor in Adenta and one in Medina. It doesn't make any sense. There has to be a way in which these cities are reimagined, re-amalgamated, and so on, or have to be amalgamated, or some even separated, some put together. But that would not be able. You can't do that in the constitutional design. It needs something more than that, and a devolution commission can do that. So I think those are some of the things that it's not ignoring the problem, because it identifies the problem that is there, but it doesn't see the solution in just prescribing a direct response to that challenge in the constitution.
Oliver, I wonder what you make of that, particularly the local government argument, because for so long we have been talking about electing MMDCs. In fact, under President Akufo-Addo, we came close to changing the constitution to that purpose, and then there was a disagreement about politics and all of that. But of course, there's still the argument being made now that certain places may not be viable enough to go and put or allow them to elect the MMDCs and all of that. Of course, you look at the local government administration system. Let me look at Accra. There are so many small municipal assemblies, when you could have a very powerful AMA that could be doing something much more than you have these small ones doing, without being able to even deliver, being able to even raise revenue.
I completely agree. I mean, our district system has gone completely out of hand, right? Like when you think about, like what everybody in the past few weeks, we've all been talking about the New York mayoral race, right? And this is like a city that controls budget, which is, dwarfs even Ghana's budget. And if you had like the whole New York City in Ghana, would have parceled it out into at least 15 districts.
Yeah.
There's a problem. There's a problem in how we were giving these things out like confetti. Every stop you make, everybody is promised a district along the way, that we need to re-rationalize this. Now, as to whether or not the Constitution review itself was provided a context to now say, no, this district should be merged with another, or all kinds of things. Of course, the framework for that decision making doesn't exist. But thankfully, the mechanism has been created for us to go back to the drawing board and rethink. Now, it's of course, and perhaps if I'm going to be a bit critical here, I would say that essentially you have, when the 1992 Constitution was created, the hope was that institutions would be able to live up to expectations and do the work. Here again, you're placing faith in institutions. And there's no magic to it, right? Like nobody can do the job for democracy to sustain itself. You have to be able to provide a framework to guide them and hope that they're able to be faithful to the execution of that task. Understanding the mandate is that we need to be able to provide a theory of how we devolve power, of how we be able to reorganize the districts. We are able to do this without political pressure. And that's important. And outside of that, if it comes back and folds into the ways in which 92 institutions have been running so far to date, we can in fact unravel some of the forward-thinking momentum that the review is providing us. So I think, in my opinion, I think it's a fantastic way to go about a problem that needs a deeper political solution.
Yeah, I think one also big thing that in the past few years we've been talking about is corruption and fighting corruption. The Constitutional Review Committee, Dr. Sante, they are thinking of taking away Srage's anti-corruption powers, merging that with the OSP and setting up this independent national corruption body. I mean, I see that Karim, Nana Kwame Hajim Jabu is on, and I would like to take his thought at some point. He has some very strong ideas on some of this. There are people who say that we just like creating a lot of institutions, and then they are nice, you give them very nice names, you put them people there, and then they don't do anything. Perhaps the question is, do we have some sociological underpinnings for why we think that will work? Why hasn't the OSP worked? Or at least for now, that is the kind of popular belief that the OSP hasn't worked 6-7 years since it was founded, or Srage, or the Attorney General. Why isn't it able to do so? So what is the idea that you put together such a committee, an independent commission of a sort, you give them so much powers, and then maybe by some magical wand, all of a sudden, they're so effective and they're catching all the corrupt people who are making Oliver Gray all of a sudden? Doc.
Correct. Yeah. No, so yeah, I mean the proposals around the accountability framework, I think are critical, and it's come from a lot of reflection. I mean, the OSP's position, the issue about whether it's worked or not, I think it's only the political class who believes that it's not worked and want to get rid of it. All the others that have not worked are still there. Nobody's talking about that. But I think it's come from a lot of reflection. So you have to go back to the African Peer Review Mechanism assessment of Ghana, where it was made clear that the challenge of the Attorney General holding the power of prosecution when it comes to corruption, particularly corruption of his own colleagues, being a member of parliament and being a member of cabinet and so on, was a challenge. And therefore, they needed to be, at that time, it was to separate the mandate of the Attorney General as Minister for Justice from the Attorney General, so that you can have an independent Attorney General, right? And then the minister can advise the president, right? So this has been coming for a long time. And then in 2017, the MPP, also during its campaign, did mention that it wanted to create an office of special prosecutor, purposely to deal with this question by targeting politically exposed persons. So we've had this conversation, and all has, it surrounded this idea of the Attorney General's powers, particularly prosecutorial powers. So when the OSP was created, I think everybody believed that, yes, if the OSP, does not have to go to the Attorney General for a fiat and can't make these decisions independently, it would work. Now we've known what has happened in terms with the OSP, with Amidu first, and then Mr. Jabin later. But it is clear that we don't want that to work, which really tells me that that is what is going to actually fix the problem. The issue was that maybe the statutory process that was created that created the OSP has a fault, and therefore we need to fix it in the constitution. So what the constitutional review process or proposals tries to do is to fix it. And then what it then does is that then all these turf wars and competition and all of that around who manages and deals with anti-corruption is sort of addressed once and for all. You have one entity that does that. For a long time, we have talked about the separation of strategies, anti-corruption from the human rights, because having that tri-mandate, there's always going to be one that suffers, right? So if we want in this day and age to have a purpose-built anti-corruption, specialized agency that is able to go after the most powerful in society, mostly political class, business class, and so on and so forth, they have to have independence. And that's what it is aiming to do. So for me, I think what is proposed is the fix. This unwillingness to allow this type of institution and framing to exist is where the problem is. And I think as citizen, I see myself as a citizen that wants to always protect the public purse. I think this is the scheme that would deliver for us. The status quo does not work. The only type of prosecution we have had since 1992 is post-regime accountability, bar Asibit and Abuga Pele, and then maybe under Kufuor, Malamisa, and so on. But when it comes to political actors, it is only when you have a change in regime that you have that, which affirms the point that an attorney general who is a member of cabinet that controls prosecution on corruption will not deliver.
Oliver, I want to hear you on this.
There's a question where you asked more generally about, the creation of institutions more, broadly. And I think there's a deeper crisis of the state, right? Which we all don't know how to do anything about. And so we are left only with continuously tinkering with institutions. Maybe if we give this more power, maybe if we pass another law, maybe if we do, we can't seem to figure out what is broken. And I think I trace it to, I think there's a value system and there's an integrity problem that we're trying to use institutions to fix writ large. Because if you have a country in which, the vast majority of, the political class, public officers, individuals do not exhibit rule-following behavior, you run out of, prosecutorial resources. You can't chase everybody. You have 1,000 people who are driving on the shoulder of the road every day. But how many of them can you continue to arrest to solve the problem? Then you're dealing with Galamsey here. And then you're dealing with, the president announces a big push project. And then people are already meeting to think about how they can, what kind of deals they can do to be able to get a cut here. It's like, it's nonstop, the scope of the problem, And so, yeah, we will try an experiment. Like, we tried with the OSP and now we figure out that, okay, the source of the problem has shifted somewhere else. Now it's about the challenge of whether or not it is set up properly and whether or not it has constitutional mandate behind it. So we'll give it constitutional mandate, notwithstanding the fact that we have a host of constitutional institutions which we can't even figure out whether or not they're living to potential. But, well, let's do that now and then we'll cross the bridge later on. So perhaps it's not a lawyer's way to, reflect on this, but the problem is that it's a widespread general breakdown in the states, what should hold a state together. So, we have to continue to do this somehow, and then we'll move on, and perhaps people with better ideas know how to fix this republic.
Yeah.
But I think that's what we have here. We are engaging in more tinkering, and in the hope that it produces results. But you can trust that, politicians will be ever resourceful to figure out new ways to shift the issues we're talking about to different planes of playing, which we have to continue to keep up with.
All right. So if you're a participant and you want to see something, you have some questions, please get ready. I'm just going to ask Noah one thing, then I'll come to you. It may be a contribution, it may be a question, but you have to keep it crisp. And then we can move on as we get close to just about wrapping up in about in maybe in half an hour time or less. Oh, Noah, I've been on a podcast with you, the CDD podcast, where you talked about. There's a point that you made that I had not thought about, and Dr. Kojo Asante alludes to it: the post-regime accountability, because really, I mean, the NDC can be as corrupt as they want. If they don't get caught by Justice Sai and Dr. Aini today, they can be sure that the next administration will come and chase them. And so it seems as though there's a certain revolving way of us dealing with corruption, especially among the political class. Whether or not we are expansive enough is another problem. But whether you like it or yes, as soon as this government leaves, if the next comes and it's from a political party that is not the NDC, they'll find a way to go after some people within the NDC. And so that kind of thing works. I wonder how you tie that in with what Kojo Asante makes, also Oliver, and this recommendation about this committee and how we believe it may work.
Yeah, so I think for me, fundamentally, we've always seen that in practice. The question for me is whether or not the real objective in those kind of prosecutions is to bring a criminal to justice, or is to tackle the interest of the base, right, of the party, so that it will seem as if we are going after these people, but we are not really interested in convicting anyone. So, look, I believe that if the NDC leaves power and the NPP comes, the NPP is likely to go after NDC guys that they believed, or there are some pieces of evidence suggesting that they were corrupt. The same will happen if the NPP leaves power and the NDC comes. So I believe that the OSP's real mandate, and why the OSP is important, is not because there will be an absence of prosecution. I don't think so. Because as for the prosecution, we were always seeing the prosecution. The question was whether or not they were carrying the prosecution to term, so that there will be convictions, or there will at least even be some acquittal in court. We were not seeing that. So when the new AG comes in, maybe they'll file a nolle prosequi, the case are terminated, and then we just go through that same cycle again. And so whilst the OSP comes to solve that problem, because now you have an office that you can say is not part of the politics, right? And so it is likely to carry those prosecutions to term and secure you the conviction or the acquittal. My challenge has always been the process for appointing the OSP, right? Under the current OSP Act, it is the Attorney General that appoints, right? And likely, most likely, the Attorney General is going to appoint, the Attorney General is himself beholden to the President, right? So this decision is going to be made, whether we like it or not, by the President and the Attorney General, and they're likely going to appoint someone who favors that party in power that is going to appoint. We have to believe that, or we have to take it as the most likely outcome if the appointment process is in the hands of the political actors. And so I think what the committee proposes seeks to address two major issues that we have noticed, at least in practice, with the OSP. One is the appointment process, so that you appoint someone who is not really politically exposed, or who doesn't come with that impression that the person has some political relationship with the appointing authority. So if you look at what the committee is proposing, there is going to be if it is adopted, there's going to be a very meritocratic process in appointing whoever is going to be in charge of the new Anti-Corruption and Ethics Commission that the committee is proposing. So there's going to be very little politics in there, or little political control in appointing the person, apart from the person going to Parliament for approval possibly, and then being confirmed by the involve major political control, political input, right? The other thing that I think the committee seeks to address with the Anti-Corruption Ethics Committee is what Dr. Asante has already mentioned, which is that now we have so many bodies actually engaging in these kind of corruption investigation. Currently, Shraj can do it, and the Attorney General himself can do it. And then we have the OSP, Yoko, all of these institutions. So there's usually a tough war, because between the AG and the OSP, the one who has the case will always be the one who makes a public statement first, like it's investigating the case. Then that's why we are seeing the OSP the OSP being the media a lot of times, always saying that I'm basically investigating this matter. It is a way to tell the AG that I'm investigating it to back off. When the AG also comes into the public so that I'm investigating this corruption-related issue, it's a way of telling the OSP that I'm investigating this matter, so back off. So what the Anti-Corruption and Ethics Commission will do is that it is going to bring all of these corruption investigation within its domain, right? The Attorney General will not have that mandate to prosecute those cases that the OSP is currently handling anymore. It's going to focus on those general criminal prosecution involving stealing by private individuals, murder, those kind of issues that do not involve political actors and does not implicate corruption. So now we have a territory, a jurisdiction carved out specially for this Anti-Corruption Ethics Commission so that we do not see the push and pull between various entities. So that cures those two practical issues that have become more apparent with the way the OSP has operated since its inception.
Okay, so if you are a participant and you have some comments to make, please you may raise your hands up. If you have a question, please do so too, and I'll be very, very happy to let you speak so that we can all get to know what you think about some of the things that our panel have been talking about. And so if you have any comments, just you raise up your hand. I'm sure it will just pop up, and then we will see it. Oliver, 10-year tenure for EC, Supreme Court judges. I mean, a Council of States with sort of new fresh powers and new things to do. Yeah, sounds interesting, right?
I mean, I think so. I think, well, let's talk about the EC. Well, they also deal with the, I don't know whether to call them non-executive commissioners or the part-time commissioners, who we don't really understand what it is
that they do,
their role is, or what they do. But I think we are seeing, particularly after Afari-Gyan left, the increased activity around the EC's office, and then it's become part of the political competition. You know, and this is some attempt to be able to create some sanity around this, or perhaps give you an indication that, well, a fixed term perhaps better insulates an office. We've tried a fixed term idea with the OSP, and now we're kind of constitutionalizing it this way, that okay, maybe if they realize that the person is not going to be there for forever, they might be inclined to live with it, so to speak. You know, I'm not opposed to the idea. The chief justice one I find quite interesting, because they're proposing that you do the chief justice, that's I think 10 years, and that the person can then choose to
go back on the
court or go off. I would rather the person retires, right? I don't think there should be room for the person to continue to sit on the court after they have become chief justice. But also raises a very interesting point, and perhaps since there's a lot of, you know, this is a law students conversation as to whether or not the chief justice is a Supreme Court justice, and we know that these questions are going to come up in the what's the name? The former chief justice's suit, whether the chief justice is a member of the court or it's a separate office in its own, so that once you finish it, you then, you know, are you then reappointed to the Supreme Court, or you just somebody who is a Supreme Court just performing just additional administrative duties, you know, those kinds of conversations. I think from where I sit, I would have wanted perhaps, you know, a removal of those 15 years at the bar, 5 years at the bar, those restrictions, which I think are no measure at all of a person's quality or otherwise. But those stay, and I don't think I feel too strongly, to be honest, about the term limit for the CJ.
Yeah. Is there anyone that will want to say anything that has a contribution to make, a question to ask about, or where we have been so far? Please, if you do, please raise your hands up.
If you don't mind,
okay.
I was going to talk about, I mean, particularly because of also the context of the conversation we're having, that this is it's one of the once in a lifetime thing. I mean, this is the third one we're being on, but I do think it is an important point for law students to also kind of figure out, in this moment, what role does one play how does one plug in into the conversation? How does one carry it forward and challenge it, whether or not we are passioning it out into moot courts or people are becoming more interested in writing about it and reflecting on the new changes that are upon us. I think I would definitely like to see more discussions from the law schools in terms of what they're thinking and what the new ideas that are put on the table entail and how do people feel about them. And I hope that this, a platform like this can perhaps serialize the different things within the constitutional proposal. And even as we go down the roadmap for implementation, that more conversation will be generated around it. Yeah.
I mean, I don't know how it was like in Dr. Kojo Asante's time. I mean, these days it's I mean, you go to the law school, it's really about
I'm not that the way you talk about me, as if I was
you are very old, Kojo.
I was called in 1953.
Yeah, but the point I wanted to make was that, I mean, among law students now, there is that depth in idealizing things, talking about things. I mean, I'm certain sure that Oliver's time with Justice High and Co, there was this kind of idealistic thing. These days, it's really just about go to the class, learn and go. And I think even 5 years, just 5 years ago, when I was doing a different course other than law, I mean, people like Selikim, Noah, they were writing consistently. They were pitching in ideas on different things. It's almost like it's not there anymore. Even in the entirety of the education system. I mean, I look back at University of Ghana now. There's almost no activism now. There's almost nothing, right? So it's a question for all of us. I mean, to look at in a kind of education system that we still have, whether we are getting imaginative students, we are building imaginative students, or people that just want to go to class, do some rote learning, pass, get called to the bar, and then go back into the system, like that.
Yeah.
Sir,
But,
no,
yeah.
sir,
I think
somebody.
Yeah, we need to mute them. But
Okay.
Doc, please let me hear you.
So no, I hope I can make a pitch here, because I mean what Oliver says is very important. I hope this would motivate some of our colleagues at the law schools to get involved. I mean, we are part of a civil society platform on constitutional reform. We launched it last year, and we're going to be rolling out a lot of activities, and we really want the lawyers, as we said, is once in a lifetime opportunity to really, help sort of build a new constitutional order for Ghana into the future. And one of the reasons why I think law students, should get involved is because I was taught that law is a tool for social change, and lawyers are really change makers. Maybe these days people contest that and say, well, it's just to pay the bills. and to build a future, an economic future for people, but law was seen as a tool for social change. Every lawyer is by default an activist, because you are always seeking to test the law. It's always all about what the law ought to be and not what the law is, because you are always seeking to test the limits. And the law is supposed to be problem solving. You design the legal architecture in order to respond to a particular problem, right? So if that problem is not being resolved, then you have to look at that design again. And I think that students should get involved. But I also think that, I mean, a lot of law students, I don't know the age demographics, but I would submit that most will probably be under 35. And that is also about securing the future for the youth of Ghana. And it's my future, but it's mostly the future of young people who are in the majority in this country. And I think law students are sort of well placed, to push this agenda. What we are, for example, I've spoken to Otenewa that we should be able to train some of our law students so that they can be, facilitators in communities, to discuss the Constitution, as we we begin to engage on the process of implementation. And I think that would be also a good way. But I also like the things like the moot courts. I mean, what Oliver talked about, even in terms of the tenure, you know, I asked the same thing about the IGP. He was a very young IGP who's gone home now, and I'm wondering why is he just sitting at home? Can't he be still a commissioner of police working? You know, so there are some interesting questions to debate, discuss, but really test the principles that underpin a lot of these laws that we have been talking about.
Yeah. And colleagues, we want to hear from you. I mean, obviously, this is about us. We organize this to sort of get an understanding of what is going on and our own views. So please raise your hands up. We're just about winding down. Want to hear from you, your own views. If you have some questions for this very distinguished panel, then we'll do so. Please just raise your hands, and then Otinewa and I will be very glad to let you in so that you can have your points. I mean, final round of questions, really. There's a lot of expectations. Are we able to go over this? Because after this year, and in particular next year, in reality, we have 2 years to do something. Because 2028 is an election year. And in election years in Ghana, you're not able to do anything meaningful, at least from my own understanding of what has gone on over the last few years. So Noah, when you guys did this work, did you give yourself some timelines, or you just wanted to stick to what you were given to do, draft the proposals and submit it to the government? Because here we are going to 1st February. We haven't heard from the government since then about the implementation committee. I've heard Oliver backing the government on why they don't need to put up a white paper. I think elsewhere, the AG might have also said something different recently. Well, like, we need to do something before we run out of time, because then when you get into next year, then you're inching closer to an election. You already have the government in waiting, the possible government in waiting, having elected a flag bearer, which means very soon, you know, in this country, and especially because this Constitution Review Committee has a recommendation that will limit campaign period to a certain point. We don't have that yet. And already, you know, this place, we live in endless cycle of campaign and political activities. What are your own expectations of how fast we can go to get part of this done?
So I think I've been with the committee in a number of conversations with key stakeholders, the minority, the majority, the presidency, and I see that drive to make certain changes to the Constitution. So I am very certain that in this year and then next year, a number of the recommendations that will achieve bipartisan consensus would be will go through, especially those that are non-entrenched and will have to go to Parliament. So I am very convinced that with the political will that we are seeing from the political class, it is very likely that we will get some of the recommendations through. I think the challenge will be with the referendum. And even that, I don't think it's a lack of the will. I think it's the technical issue on how to get a number of the issues through referendum. And I think that's what the implementation committee will be called upon to help steer to the finish line. But I have to say that the reason why the government has not announced the implementation committee is largely, I think, is because the committee, the CRC, had not submitted its full report. Yeah, which I think it did just last Thursday. So I'm sure in the coming week, we are likely to see a statement from the presidency acknowledging receipt of the full report, and maybe that will be the base on which it announces the implementation committee. And I think once the implementation committee is announced and it begins its engagement with the key moving parts that will lead to these recommendations materializing, I think we will see. I'm very optimistic because of the kind of engagement that I have listened to from the different stakeholders who at least they are at them that we need some tweaks to the Constitution to support what we want to achieve in our development drive. So I'm very certain that we'll see some of these recommendations pass. But one of the things I want to say, adding to what Doc and then Oliver said, is the place of law students, right? Through my time as a law student and now that I'm a lawyer at the bar, I have seen and believed that law students even have a kind of voice that non-law students do not generally have, right? And for these recommendations to materialize, we will need the public to be carried along as to why specific recommendations must go through. And no person or no group of people are placed in a better position to do that than law students. And no better category of law students to do this than those at the Ghana School of Law, right? And so I believe strongly that this is the time that the law students individually and collectively under the umbrella of the SRC, for instance, maybe to be putting down committees on their own to be reviewing the recommendations and coming out with certain responses on the recommendation. What's the position of law students to support the process? Why they think this particular recommendation should be carried through? Why they think this is not negotiable? We have to get it across the finish line. And these are some of the conversations I think law students should be having in their private capacities and collectively as an SRC or as a student body. So I'm looking forward to those kind of conversations so that at least there is pressure on the government, because like you said, when it's getting to election period, governments will start thinking about winning the next election, right? And that's when we come in to say that, you know what, you promised us amending the constitution. And those are big ticket items that we'll have on our mind when we are going into the next election. If we don't see the recommendations materialize, we wouldn't treat as the government doing what it's promised to do. So I think these are some of the conversations we should have also as law students.
Yeah, Oliver, are you confident that we're able to get this done? That this report does not end up on the shelf like the Professor Fiajo Committee report, the Clara Berry Committee report, and that this really is where we move forward.
I was going to say that Noah's optimism reminds me of where I was when we finished with the Fiajo report as well. Like I was certain that, listen, this is it. Like, you know, all the political parties at the time were talking about constitutional review. It seemed just ripe for the moment, you know. But listen, I think one of the things we have to appreciate is that these projects more often fail than they succeed. And if that becomes a driver of how we are seeing this, rather than seeing it as like a done deal, sort of, we would then, you know, lift the foot of the pedal with respect to how we need to mobilize people, how to be able to ensure a frenzy around this conversation so that it doesn't become a blip and then, you know, it becomes so disengaged that it becomes like an expert conversation or an elite level conversation that people are not able to bring the people along. So even in terms of, you know, what Kojo was talking about this citizens platform that we have put together, I think there's a lot of work that must go into going into the communities, educating across the districts and towns and whatever it is. We really have to see it like the PNDC's cocoa initiative, where university students have to go into the farms to go and help carry cocoa bags. Like, we have to be that engaged on the ground, you know, getting people out as much as possible to be able to generate enthusiasm around this. Because if you leave it to the political class, first of all, they'll renegotiate this in a way in which will be so unrecognizable, particularly if it doesn't seem that the people are willing to invigilate the process going forward. And we must, you know, be able to put people into that position to do that. But there's a sense of, I think in some regard, you know, the continuous talk that, you know, John Mahama must leave a legacy, and that this has been suggested as one of the legacies that he should leave, becomes an extra incentive for those in power. And hopefully that enables us to carry through. And hopefully that doesn't also, as we know how binary our politics is, it also means that as much legacy as he wants to create for himself, there are people mobilized enough to deny him that legacy. And so how we can be able to ensure that this is also doesn't become part of the, you know, the political rhetoric of the oppositional politics or the oppositional nature of our politics is also something that we need to be able to account for more generally. But I do hope that, you know, young people and even, you know, young law students help unblock our generation's attempt to get this right, and that we are so implicated in the process to be able to move this forward. So let's see how the process unfolds, and I want to be cautiously optimistic. I'm definitely a driver. I'm interested in how we, you know, even at Democracy Hub, can be supportive of the process going forward.
Brilliant. So, Doc, I want you to chip in on that, but we have some questions. And this one says, for Dr. Asante and Oliver, They expect law students to engage with the process, but that's based on the assumption that law students have the capacity for activism. What opportunities are they offering to help students write, express themselves, and generate content? Basically, build their capacity to do the things they expect of law students. So, Doc, this part of the question is directed at you, but I want you to take that as well with the hope that we can get this particular report over the line.
Yeah, I mean, we've talked about having some, capacity workshop because, I did talk about the motivation and the logic around the constitutional review process and the proposals. So it's important that if, for anybody to sort of really be able to pronounce, and you need to understand where the committee is coming from, what problems they are trying to deal with, and a lot of these problems may be social. I mean, there are even very specific provisions about how we manage our fiscal issues, our finances, how we manage the public service. So there are many areas of expertise that has informed where we are. So it's good to be able to, have engagement with people who are coming from that perspective, and then you can apply your legal language, and then also, if you want to be able to help as a facilitator and so on, you go there more informed, also to get feedback, from citizens around these kinds of issues. So as the platform, I mean, that is one of the things we really want to do, to be able to have these kinds of, I would say, workshops with students who may be interested, so that we can build their capacity to be able to do this kind of work. I mean, this is not going to be a one-day show, really. It is something that I believe will carry on maybe for the next 2 years. So there's a lot that we can do together. On optimism, as I said, for me, I'm invested because I really want to. I don't want to live with regrets and the constant complaints that I have about Ghana and its unfulfilled potential. I want to be able to live and enjoy that potential, and I think it's within us to be able to do it. So I'm invested. I'm optimistic, and I believe that if it fails, then it means that citizens have failed to make their voices heard, and civil society, have failed to mobilize citizens to be able to, impress on and push, the political class to do the right thing. So there's no room for failure, unfortunately, because if we fail, I really think our window for correcting our current governance deficit is closing. If we don't do that, I think then we leave ourselves to a lot of confusion, if things don't work out.
Yeah. Oliver, I think you want to chip in on that. The idea of building the capacity of law students to be able to do this because of all that.
Yeah, I mean, I was part of the citizens platform for reform. We've been having some of these capacity building conversations even prior to the report coming out. With very different kinds of groups. We've had youth groups, media, and all kinds of different. And I think there's definitely scope that we created. I mean, Kojo is here as well. And what was the internet, that we can be able to bring people on into the process, as much as possible, educate people about what has happened in the past before, what is currently happening now, have a conversation about the content of it and what are the general issues, but also understanding what a roadmap to reform would look like and how people can engage in that conversation. So that when you go into any space, you can then also speak competently about, what it would entail, what it would look like, and answer kind of questions that will come from people. But there's a real sense among on the citizens platform that we want to draw in as many, law students as possible to help with community level education across the country. And I think that's a framework which I know that we'll be very keen to work with the SRC and different kinds of groups on campus to be able to achieve this.
Yeah,
and that's something we are committing to. Yeah.
This question is for Noah. He says, Noah, how will you be disappointed, and how do you think your committee will be disappointed if some of the recommendations are implemented rather differently than what the committee had anticipated? And what is what is for the committee will look like success post the submission of the report?
That's an interesting question. Now, I think for one of the first, I've had a lot of growing up to do personally through working with the committee, right? Especially on my thinking on a number of things. And I think I remember one of my first engagements with Prof. Prempeh, he mentioned that one of the key ends of the committee's job is to present a good report based on what it has heard from the people and the outcome from its thinking through what it has collected from the people. That in itself is a success for the committee, right? So the recommendations in that document that has been submitted to the presidency is in itself a success, right? But the committee also understands, at least as I learned from them, that the report must go through some other processes for it to be turned into those amendments, provisions that we will see materialize in the Constitution. And they understand that it is possible that it may not end up at the end of the process in the same format that they put it in, right? And the committee is not really worried about that. Of course, they would want the recommendations to pass, but they understand that it is not all of the recommendations that will end up being translated into amendments provisions. Like I said earlier, if we end up having those recommendations that touches the essence of the committee's objective, which is to make the Constitution a more developmentally focused Constitution, that is a success for the committee. So things like rearranging our decentralization or local government sector to ensure that there is development that is at least bottom up, that in itself will be an achievement for the committee. Rearranging the executive, freeing the president some time or some space to govern. Those are translation of success to the committee. Whatever formats it will end up taking in its final stages, I think what the end goal for the committee is not that black letter writing from the committee will end up being what we see in the Constitution. It is that the conversation that the report is going to raise in different aspects or different quarters of Ghana is going to lead to certain changes that will ensure that our Constitution now becomes more focused on development than focused on the electioneering process alone. So I think that's how we are going to measure success. Not necessarily having all of the recommendations pass, but having a shift in the focus of our Constitution and the focus of our institutions to development than just the next election cycle. I think that's how the committee is going to measure success.
No, this again is for you. He says, what is the priority reform you would like to see executed the way you imagined when researching and drafting the CRC report?
I think if there is one recommendation that I would be so excited to see is not having members of parliament double as ministers. It's something that is so important to me because of the culture around our politics, right? Maybe in the next 10 years, things might change and this wouldn't be a problem. But for now and the years ahead of us, I see that it is going to be a serious impediment to our development as a nation if we have executive control of the legislature. And this is primarily done through the president appointing a majority of his members from his cabinet members from parliament, and then also having these same parliamentarians sit on boards of state enterprises, and then exercising oversight responsibility over this enterprise and then the executive. So I want to clearly see that. And I think when we are able to achieve that, we'll have more parliamentarians who feel free to speak their minds on issues that really affect their constituents. Because now the parliamentarian will be more concerned with the election he has to win based on the sentiments of his constituents and not necessarily only satisfying the interest.
I think Noah's thing has frozen a little bit. So, Otenewa.
The other thing I think maybe will be with our judiciary, right? I would love to see the judiciary more independent than we now. right? That is also one of the things that
I think there are a few challenges with Noah's line. It keeps dropping, but I think you made the point quite forcefully. So if there are not a lot more people putting their hands up or sending in questions, I think Otinowa, you can come in now and then we can begin to go down. I think Otinowa's video too is a bit frozen. Okay, Clinton, Deborah, your hand is up. Let me hear from you.
Yes, please. Thank you very much for the opportunity. I really enjoyed listening to our panelists tonight. I really learned a lot. So my contribution is that I am of the opinion that I think midterm elections is one of the key ways of holding the executive and then the parliament very accountable. We notice that usually it is during the election year that the political class tend to listen and try to do more for the citizens. And some of them, yes, are a bit cosmetic and rhetorical, but then at least you see that they care enough to do something for the citizenry. This is, and I feel like we can take that and then translate that into midterm elections or staggered elections where we have our parliament, we have half of them, or at least more, or a section of them being voted for every 2 or 3 years. That way, it's a good indicator when the government loses the midterm elections, let them know that there are certain policies or certain things that they are doing that is not in favor of the people, especially since polls don't really seem to gain traction much here in Ghana. So midterm elections is a very good way of putting pressure on the government to do the work or fulfill the promises that they've made. And also midterm elections the way of holding the parliament accountable, especially if one of the recommendations that Noah and then the committee was putting across that parliament, no ministers, no Article 78 one basically. I think that's a very good way of holding the parliament independently accountable too. So this is what I think and I want to put across. Thank you.
Yeah, thank you. Thank you very much, Clinton. Interesting thoughts on the midterm thing. I mean, imagine when we had 137 parliament there, so there was some midterm election there where it would have been great. Oh, this one, Christopher Wisdom Penny says, great work done by the CRC. We want to know more from him why youth issues are not treated as constitutional issue, but rather as a political issue. Hence, the committee not adopting certain key recommendations such as ensuring and defining youth constitutionally, etc. Noah, why didn't you define youth in the constitution? It's okay, youth is from this age to that age.
No, I think there are a number of, maybe when people get the full reports and they read the recommendations and then the justifications for the recommendations, I think most people realize that the report is very youth focused, right? And you can see that from some tangible recommendations like lowering the age to contest for the president and a number of things. The committee, even though it does not state it explicitly, I think you gather from reading the report that it's an attempt to put the fate of the country in the hands of the young people. That young people will have a major voice in how the nation is governed, right? There are a number of things that are not defined in the Constitution. And I think the committee's understanding is that Ghana's, for example, defining who a young person is in Ghana is going to be very difficult because we looked at a number of constitutions and they provide different age range for who a young person is. We even looked at the United Nations and other international organizations on how they define a young person. And the committee looked at it, and I think the consensus was that these are issues that are to be left to the legislature, right? Because if you leave it within the Constitution on what a young person is, and there is a change, and you have to come back to the Constitution for an amendment again, that is usually a more difficult process than when you have the legislature make definitions like how it has defined who a young, a child is. It has defined who an offender, a young offender is, those kind of issues, the juvenile and all of that. These are things that Parliament can easily define. And when there are issues surrounding that, Parliament can easily through an act correct. But I think the recommendation in its entirety is very youth focused in some of the recommendations that we see in there.
Yeah. Otinowa, let's come in now and then let's hear some wrap-up thoughts and then the team can take it.
Yeah, so I want
I think Otino's video too is a bit frozen.
That's it. Hello, can I be heard?
Yes, you can hear it now.
Okay, so Noah's point about looking forward to a complete separation of powers is interesting, and I was thinking about whether he knows of any jurisdictions in which this is actually working for them, whether it's not going to cause a complete deadlock between government and business. But then that's also something to ponder. I think it's been a very interesting conversation, and I'm definitely going to be in touch with Oliver and with Dr. Asante for the platforms through which we can come on board to contribute to the outreach. And thank you so much, Kweku, for this excellent moderation. Thank you to our resource persons for your time.
Yeah, brilliant. I mean, it's not always that you get this power panel to discuss the constitutional review. Oliver Barker-Vormawor, he's always had a skin in the game. Noah Damte, this particular one had a big skin in it. And Dr. Kojo Asante has always very, very key when it comes to some of these civic. Otino is still speaking. I think the Otino's network has a little thing with it. But yeah, for all of you that joined in, hopefully, I mean, I like both Dr. Kojo Asante and Olivia's point about getting law students involved in the civic space, getting more and more people to be speaking on these national issues. I want to be seeing articles flying all over, people talking about national issues. At the end of the day, these are the young people that will take over from the next few days, especially now that if these reports have adopted, a 35-year-old can run for president. I mean, so it will be interesting to see how all of that goes. Thank you very much, Otinowa, leading the SRC to get this done. Thank you very much, Noah. Thank you, Kojo Asante. And thank you very much, Oliver Barker-Vormawor. For those of you who sent your questions,
Thank you.
and those
Thank
of you who
you.
joined,
Thank
thank you all
you.
of us. We'll see you another time.
Yeah.
Okay, do have a lovely evening, everyone. Thank you once again.
Thank you, Otiniwa.
Thank you too for your time.